And I was like, I was just saying, hey, I apologize. I'm just looking for solutions, da da da. And she's like, well, you need to give him time to heal, and then he'll heal on his own time. And she said, you don't have to be dismissed. Okay. Shh. And she's like, well, you
Okay. All right, the meeting will now come to order. Welcome to this meeting of the Charlotte Unified Board of Adjustment on Tuesday, April 28th, 2026. My name is Deborah Dryden and I'm chair of the board. Would the board members please go around and state their name for the record?
Marshall Williamson. Devin Shade.
Amy Ling Yisan.
Hamilton Court.
Thank you. Also present are John Kinley, the interim zoning administrator and senior project manager, Crystal Monsegur, our planner, Kamisha Lampley, the clerk to the board, Therese Hagler Gray, senior assistant city attorney advisor to the board, to the planning staff, Paige Inman, assistant city attorney advisor to the board, and you give me a card, I don't have it written down. And Elizabeth Myers, our Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinance standards, not personal preference or opinion. General witness testimony is limited to facts. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully, and parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show that they will suffer special damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing that may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by an affected party. Today's meeting will follow the order printed on the agenda. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case, and any sworn witnesses provide testimony. The board and city staff may question the applicant and their witnesses. Other parties wishing to speak for or against a case will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or the appeal. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign-in sheet. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board to the Mecklenburg County Superior Court, you have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D-405D. All right, at this time, I would like to swear in the staff. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. All right. We will now open the evidentiary hearing. Before we do that, Paige, on the other agenda items, two of the cases have requested a deferral till May. Is it okay to do that now? All right, board members, if you will look on the back of your agenda, variance 2025-00050 and APL 2026-0003, both have requested deferral to May 26th. Do I hear a motion to approve those?
So moved.
Thank you. Do I hear a second?
1 second.
Okay, thank you, Ms. Sun. Okay, and if you'll note that also for the record, variance number 2026-00012 was withdrawn. Okay,
We need to vote.
okay. We already,
Right, do we need to vote or we?
oh, okay, so we need to vote for this withdrawal due to zoning administrators.
I don't
setback.
think we,
Okay.
no, yeah, we don't need to.
No, we don't have to vote on that. They just withdraw it.
I think
It's
the
only the
applicants in the
appeals that
room-
we have to,
We can clarify for the record that that one is withdrawn.
It, the zoning administrator interpreted that a variance was not needed, so we're through that.
okay, all right,
Yes.
okay, it's pretty good. All right, this, okay, all right, so now we will, go to the regular agenda. This is variance number 2026-00008.
Hold on.
What?
We have to vote on the difference.
We already did.
We just had.
We got a second.
Oh, I beg your pardon. It's been a long morning. Okay, so Mr. Court made a motion to accept the request for deferral for two cases. Ms. Sun seconded. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun, Mr. Court,
Court, yes.
and Dryden, yes. Thank you very much. Okay. All right, now I think we're back on track. Okay, all right, go ahead.
Good morning.
Good morning.
I will be presenting case number variance 2026-00008. The applicant is Michael J. Montrich, represented by David Murray of Murray Law Firm, PLLC, for property located at 118 McCalloway Road. And the property owners are Michael J. Montrich, if I'm getting that wrong, and Catherine R. Jackson. The variance is from Article 4.3, Table 4-2 for setbacks for N1A zoning of the UDO to reduce the required rear setback of 40 feet to 23 feet, a 17-foot reduction. Exhibit 1 shows the vicinity map, and it is located south of Charlotte on off of Randolph Road. Here's the aerial map on Exhibit 2. It shows the property. And the zoning is N1A, Neighborhood 1 zoning districts. This is, Exhibit 4 shows Google Maps street view of the property. This is the house here. And here is, on Exhibit 5, shows the Google Maps bird eye view of the rear of the property. I just wanted to show you while I have this slide up that there's some topo changes in the rear. The variance request is to reduce the required setback of 40 feet down to 23 feet, a 17-foot reduction. The applicants offer and agree to the condition of the variance, that the variance is only applicable to the existing single-family home structure and deck, future renovations, additions, extensions thereto, and replacement thereof, if damaged or destroyed, as set forth in the UDO section 38(3)G. And here is table 4-2 in the code. It shows that row D, the rear setback is required is 40 feet. Can't move that. Looking at the survey on the left, here's existing home. This is the required rear 40-foot setback. The home encroaches 17 feet. And the reason for the encroachment is that it's legally non-conforming. The home existed, was built in 1958, which was prior to the legacy ordinance. On the right side, you will see what they're proposing, which is a 23-foot rear setback. If granted, it would bring this existing encroachment into compliance. And here's the proposed addition. It's not going to encroach further than what is existing. There is an existing roof ridge line here. Pointing that out because if it would be proposed to be extended as well. If they did the addition in the front, the proposed ridge line would cause them to have to grade additionally in the front. But in the rear, there's the topo already going on, so it would level out. The excuse me, the N1A zoning requires a 40-foot required rear setback line. Just showing you in this image that there is an angle to the lot. The angle is 125 degrees. If it was 135 degrees, we would have been able to consider measuring it as a radius per the UDO. Here are some images in Exhibit 9. It shows the grade change where the dirt kind of covers up a lot of the lower level, the split level is below grade. And here's the rear. This is the proposed addition where they're going to put it on the back right side of the home. And just showing down here is the ridge roof line that I was bringing up earlier on the survey. And here is slide 10, Exhibit 10, where you can have a chance to look at your findings of facts.
Go back to that previous slide, please.
Sure.
Lower left is front view.
Yes, lower left is front view.
So in the application, talk about specifically the size of the addition, height of the addition. But you said in a previous slide of this, that the ridge line is going to be aligned.
Yeah, so the ridge line would be aligned. What I was saying was if it had to be in the front, then they would need to do additional grading to accommodate the addition. And am I explaining that correctly, Sean?
Or grading.
In the front, if they did the addition there and had to extend the ridge line.
So yeah, in the front, it would require grading because you'd have to dig out down into that partial basement. Yeah, yeah. So if they were to have to put it in the front, they would have to do a lot of additional grading. So the reason why the addition is proposed to the back is because they're taking advantage of the topography of the lot sloping down. And you can see in that right-hand picture, you get full 2 stories above the grade.
People want. Usually, right.
You mean like what the applicant,
They just block them, they should say, but how it was time.
So the additional, yeah, that additional information was provided after the application was submitted because they wanted to provide that additional clarification for the board. Yeah, it would be a two-story addition matching up to basically the right-hand side of the picture of the back of the house.
Yeah, the way I take that, they're trying to speak to the other ways of using the lot. And the other obvious way of using the lot would be to go forward, and so that they're showing the limitations on the other feasible ways of using the lot without the variance.
Correct.
With their, even though they're building the addition, it will bring the non-compliant into compliance now, if you approve this very, right?
It's a legal nonconformity, so it's allowed to remain as is, but yeah, if you approve the variance, it would basically bring it into correct compliant scenario. So if, if they were to do, some modifications to that portion, then that would be fine. Whereas now, the way it is, all they could do is like renovating enough to like keep it in working order, essentially.
Was confused by the wording.
The way I interpret the condition is that it applies to kind of additions, but it does not apply to a tear down in a brand new home. So you get renovations, additions, you can do all these things, damage, replacement, but if you decide that you want to do a tear down, we're not going to carry this.
Thank you.
okay, thank you. Unnecessary hardships result from the strict application of the regulation because N1A zoning requires a 40-foot rear setback and the rear lot line is at an angle, but the angle of the rear lot line does not allow the rear setback to be measured as a radius. The existing home was built in 1958 prior to the creation of the legacy ordinance and encroaches into the required rear setback by 17 feet. According to the site plan provided by the applicant, the proposed addition does not encroach more than the existing home encroachment. The requested variance to reduce the rear setback, if granted, would resolve the current home encroachment, bringing the home into compliance with the UDO and allow a reasonable addition to the home that is not closer to the rear property line than the existing home. The hardships result from conditions that are peculiar to the property, due to the angle of the rear lot line, the topography of the lot, and the design of the existing home. The existing home is a split level with the lower level partially below grade. Significant grading would have to occur for the addition to be located within the setbacks at the front of the home. The roof of the existing home would have to be rebuilt for the addition to be located within the left side setbacks. The addition is proposed to the rear to work with the existing grade of the lot and existing roof ridgeline. The hardship does not result from actions taken by the applicant or the property owner. The owners did not create the lot angle, and the home was built in 1958 prior to the owner's purchase in 2007. Per the UDO standards for granting a variance in Article 37(8)(a)(13), Roman numeral 3, the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. The requested variance is consistent with the spirit, purpose, and intent of the regulation in that public safety is secured and substantial justice is achieved. The proposed variance will resolve the existing home's legal nonconformity and permit a reasonable addition to the existing home that maintains the home's existing design facing the street consistent with other single-family detached homes in the area. The proposed addition is in alignment with the spirit and intent of the regulation. It is only due to the unique circumstances of the angled rear lot line and the placement of the house that a variance is being requested. The proposed 23-foot setback from the southern property line allows separation, about 36 feet, from the closest neighboring house and does not deny the neighbor of the fair use of enjoyment of their property. Granting the variance would not alter the essential character of the neighborhood. The site is surrounded by single-family residential development. The house's existing footprint covers 20% of the lot. The proposed lot coverage includes the addition. The proposed lot coverage, including the addition, is 28%. And the total allowable lot coverage per zoning is 40%. The applicant has offered and agreed to the condition that the variance is only applicable to the existing family single home structure and deck, future renovations, additions, extensions thereto, and replacement thereof if damaged or destroyed as set forth in UDO section 38(3)G. And exhibit 13 shows the sign that was posted on the property. There's no one in opposition.
All right, any other questions for staff? All right, we will move into deliberations, thoughts or recommendations.
Make a motion to approve?
Thank you, Mr. Shea.
Can we
I'm
clarify
ready.
that that's with the
With
condition?
Conditions, Mr. Shea.
Right. My apologies. I make a motion to approve with conditions.
Ms. Sun, do you second that with conditions?
Yes.
All right, Mr. Williamson?
Williamson, yes.
Mr. Shea?
Shay, yes.
Ms. Sun? Mr. Court?
Court, yes.
Ms. Dryden, yes. So the variance is approved. And now let's, we need to approve the finding of facts and conclusions of law. Do I hear a motion?
Court motion to approve.
Thank you, Mr. Court. Do I hear a second?
Second.
All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun, Mr. Court.
Court, yes.
Ms. Dryden, yes. So the finding of facts and conclusions of law are approved as written. Thank you very much. Thank you. All right. All right, now we move on to variance number 2026. 00014 for property located at 2217 South Tryon Street.
Yes. Thanks, Chairman. I do want to suggest a lot of the answers that you have questions to are in the findings of facts when I go over them. So if you can wait until that part, I'll be grateful for that. Thank you. So variance 2026-00014 is regarding accessory structure and front setback. The applicant is Joel Iverson of Monday Night Brewing, represented by Jason Dolan of Timmons Group, for property located at 2217 South Tryon Street, owned by FHN 2217 South Tryon Street LLC. And the variances from Article 17(1)(e)(1) to allow an accessory structure to be permitted in the established front or corner side setback. Exhibit 1 shows the vicinity. It is off of South Tryon Road. The zoning is TODUC, which is Transit Urban Center Zoning District. Exhibit 3 shows the aerial map and a bird's eye view. Just wanted to show you that the building that's existing is right up on the rear of the property. And just pointing out that there's 3 frontages: Rampart Street, South Tryon, and Donovan.
Okay, looking at that, where do they want to put this accessory structure?
The accessory structure is, let me just, it'll be in this slide here,
On the South Tryon Street side, okay.
yes, thank you. The variance request is from Article 17(1)(e)(1) to allow accessory structure to be permitted in the established front or corner side setback. The applicants offer and agree to the condition of the variance that the applicant will screen the accessory structure with new vegetation and provide a metal trellis nature screen on the rear of the TV screen as depicted on the variance plan exhibit. And here is part of the code where it states that the accessory structures must be, that is not permitted in the established front or corner side setback. Exhibit 5 is the site plan, and here is the existing building. The proposed accessory structure, as you said, is gonna be along South Tryon Street. And since there's 3 frontages, there's pretty much, this whole area is within the front setbacks. They're also they are proposing, as a condition of the variance, to put additional landscaping. Here is in Exhibit 6, it shows the TV. This is the front of the TV and this is the rear. And that's where they're putting the metal lattice to, as a condition of the variance, to screen the rear of the TV. And this is the left side and right side of the TV. And this shows the proposed metal lattice.
So the structure is just a big TV cabinet? That's
Great. No.
It's actually like a shipping container that they've converted to be like an outdoor bar. It'll be a bar and then they'll have the TV screen on top facing, the TV screen will face towards the building. So it wouldn't be visible from the road.
How big is the screen?
It looks like it's as tall as the accession, as the shipping container.
Yeah, I didn't see any, I didn't see any
Or tall.
dimensions anywhere.
I think there are dimensions on that just
Yeah.
might not be legible. I can see if I can figure that out.
I mean, a door's 7 feet, so the shipping container is probably 8, 9 feet, and so that thing's probably
Yeah.
10 feet above that, 20 feet tall, roughly. Maybe 18.
Multi-screen, Russ, multi-screen option. So
There was a picture of it.
yeah, but it didn't say the dimensions. Okay, sorry to interrupt.
Okay, go ahead.
Crystal, pull up the one that's the exterior elevations file. If you zoom in, it has the dimensions there on the right-hand side. It's basically, it's 20 feet tall to the top of the screen. The container is 9 feet tall.
Wow. So this might be an incredibly stupid question, but the zoning, does planning, does staff ever, is there a crossover point there where it starts looking at a billboard?
If it was advertising something to like a sign that would be visible from the road and it was advertising like a service or, you know, something that they sold there, then potentially that could start to get into sign requirements and be considered a billboard or even on-premise signage for the business, depending on what they were advertising. In this case, it's just since it's just a screen that's providing, you know, something for the folks in the beer garden to watch. There's nothing on the back side. It wouldn't be considered a sign.
But the condition, staff put this condition on specifically so it would not ever be used as a billboard.
So the applicant actually had already offered the conditions of having the metal lattice to screen the back of the TV essentially. So, you know, you wouldn't see like the electronic bits basically. And then we asked if they could add some additional landscaping and they agreed to add that as to the condition as well.
Right, because if they put the vegetation in, then from the street, all you're gonna see is kind of the vegetation and maybe the very top of the metal.
There are street trees and everything. And if you go back to this bird's eye image, or if, I don't know if we have a street view.
Yeah.
But there are some trees there that'll help, screen the structure as well.
So it's going along Tron Street,
Kind of about where that,
arrow right there.
in a dirt path, I think it'd be a little further over, Crystal, to the right, or sorry, to the left. Kind of where that square of grass area
Oh, I
is
see,
at
okay.
in the pathway that's in between the front planting area and that middle planting area.
That whole front yard is basically.
Basically beer garden,
Yeah.
beer patio area. Yes.
And I'm assuming this is a fenced in area, right? I mean, do they?
Don't know that it's fenced in. I can't remember.
Here's the,
Can't really tell from that
this is the
image.
front of the.
Yeah, we might be
building.
asking more questions. Crystal warned us about this.
No, no.
You
it's
need
just
to finish.
You might be able to get your answers from the findings of fact we already prepared.
I think there, there is a sidewalk, because one of the pictures that you showed, it looked like where you would enter, you could enter this garden. There was like a dotted line. I assumed that was for walkability.
Yeah,
So, yeah, see where there, I think those little dotted lines is where you'll be able to walk
right.
and access that screen. Okay, go ahead.
Okay.
Crystal.
And I'm up to the part of the hardships answers. Please feel free to look over your findings of facts and let
Right.
me know if you have a question whenever you're ready.
You can go ahead.
Okay, thank you. Unnecessary hardships result from the strict application of the regulation. Article 17(1)(e)(1) limits the placement for the location of accessory structures. The existing building is located to the rear of the site such that there is no rear yard and there is no side yard due to the multiple frontages. Therefore, there is no compliant location for an accessory structure. Due to the site layout, the building would need to be demolished and relocated to comply with the UDO regulations. The hardship results from conditions that are peculiar to the property because of the odd shape of the lot, the multiple street frontages, and the location of the existing building. The site has frontages along 3 streets, Donovan to the south, South Tryon to the west, and Rampart to the north. The existing building is located along the eastern property line such that there is no rear yard to the lot. The lot's location and existing site layout creates a restrictive building envelope for accessory structures that is not typical of surrounding parcels. The hardship does not result from actions taken by the applicant or the property owner. The combination of the odd shape of the lot, multiple frontages, and the existing building location are site-specific conditions that were not created by the applicant. The site was developed in 1987. The applicant obtained the property in 2021. The requested variance is consistent with the spirit, purpose, and intent of the regulation in that the public safety is secured, substantial justice is achieved. The granting the variance would permit the accessory structure to be located in a functional portion of the site while maintaining compatibility with the surrounding area and is consistent with the intent of the ordinance. Granting the variance would not adversely affect the adjacent or contiguous properties, and granting the variance will not alter the essential character of the neighborhood. The applicant is providing a condition that the accessory structure will be screened with new vegetation and will provide a metal trellis nature screen on the rear of the TV screen as depicted on the variance site plan exhibit. And here in Exhibit 10 shows the sign that we posted on property.
Any other questions for staff?
I have a quick question, and I don't want to get I don't want to overemphasize this, but the vegetative screening for an accessory structure, is the purpose of that aesthetic just to try to maintain, what's the purpose of screening?
Yes, to kind of provide some visual screening from pedestrians, people, otherwise looking at the back of a shipping container essentially. And typically those types of structures or any accessory structure would be in the rear of a property. In this case, with being in the front, we felt it would help to have since it would be in the frontage where pedestrians would be more frequent, the landscaping would be a benefit.
Yeah, the reason I ask is it seems like there's some unintended consequences that could be created by adding vegetation. And I mean, this is a really urban environment and it's getting more urban and more urban. I mean, there's some residential areas in Wilmore that are kind of across South Tryon Street from this, but you know, just when you get to a certain area where making people put excessive bushes and things like that just seems like at some point it could create more problems than it solves, and requiring them to screen it. I just don't know. Is there a place in town where that stops, or I mean, is it just, I guess?
Well, I think this was something the owner offered.
Well, no, I think the owner offered the evergreen screen on the back of the TV. And then the city said, well, can you also screen the back of the unit?
That's correct. Yeah, the applicants their original application didn't have that additional vegetation on the ground. Yet they had already provided the metal lattice nature screen on the back of the TV. And so staff requested that additional landscaping between it. Much like what the ordinance already requires for like parking, when you have parking between the building and the street, there's screening that's required as part of the ordinance between that parking and the sidewalk. So in our view, this is kind of similar to allowing something that we would otherwise
And
want to
looking at
screen
this,
the road.
Hamilton, there's several trees and lots of vegetation, so it doesn't look like it's going to stick out from what's already there.
And the vegetative screening for parking there's no point in uptown where it stops. You have to have vegetative screening everywhere for parking and.
Well, in some zoning districts, you're not even allowed to have parking between your building and the street. And,
Right.
But in the places where you do, you are required to screen it.
Okay,
yes.
all right. So,
Okay.
yeah.
Any other questions for staff? All right. We'll go into deliberations. Any discussion, or do I hear a motion to approve?
Court move to approve
Thank you, Mr. Court.
With conditions.
With
with the conditions, yes.
Sounds seconds.
and Ms. Sunthas, thank you very much. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun, and Mr. Court,
Court, yes.
and Dryden, yes. So the variance is approved. And now we need to look at the finding of facts and conclusions of law. Do I hear a motion to approve?
Court move to approve.
Thank you. Do I hear a second? Ms. Sun, thank you. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun, Mr. Court,
Court, yes.
and Dryden, yes. So that variance has been approved, and so too the finding of facts and conclusions of law. All right, now we're moving into a variance request. And this is variance number 2026-00007 for property located at 2127 Gemway Drive.
And we do have speakers for and against this case. There's
Okay.
I think looks like 3 at least signed up in opposition. And
Okay,
then we have David Murray, the applicant's representative, here to speak on their behalf.
all right. All right, we will have the presentation and then I'll swear in the people who are going to.
Are we ready?
Yes.
All right. So this is variance 2026-00007 for Northway Homes, represented by David Murray of Murray Law, for property located at 2127 Gemway Drive. Parcel number is 037064116, and it's owned by Northway Homes LLC. And it's a variance from Article 4.3, Table 4-1, Row A, which is the the lot width. And it's to reduce the minimum lot size from the required 10,000 square feet to 6969 square feet. So 6,969 square feet. And then variance Article 4.3, Table 4-1, Row C, which is the lot width. And that's to reduce the minimum from 70 feet to 35 feet. And this is zoned, property is zoned in 1A zoning. The vicinity map is, the parcel is located off of, kind of north of Sunset Road, north of Uptown. And again, the zoning is N1A, and you can see the subject property highlighted in green here. And here's a street view roughly showing approximately, this is not to scale by any means, but that's approximately where the property is located. If we go to the very end of our presentation where the slide is, there's a little bit better view. That's the lot we're talking about, where in between the fence and the wood fence and the
What about the utility poles? Are they on the property or off the property
it
or?
might be on the corner at the right of way. I'm not really sure exactly where those are. Surveys may show it. I'm not sure. So again, the variance request is from table 4-1 for the lot standards for N1A zoning, minimum lot area of 10,000 square feet and a minimum lot width of 70 feet. And the request is to go to 6,969 square feet and 35-foot lot width. So the kind of the history of how we got here, original plat from 1960 shows lots 10, 9, and 8. Those are all starred there. And then I've kind of highlighted the area that we're talking about that's subject to the variance in black. According to the applicant's timeline exhibit, in November of 2023, Northway Homes purchased these 3 lots, 8, 9, and 10, that are depicted on the Edmore Estates section number 1 plat, book 9, page 239. And the subject site is the eastern portion of what was lot 9 on that Edmore Estates plat.
So this piece of property was never really attached to anything?
It's part of lot 9.
It's part of lot 9?
Yeah.
Originally.
Yeah. And as I go through the presentation, you'll see how it is what it is
came
now.
to be, okay. I'm interested to hear that.
So then in exhibit number 6 was a recombination plat recorded in January of 2024. So after the purchase by Northway, in January of 2024, the recombination plat, book 73, page 314, adjusted the lot lines of lots 8, 9, and 10. And on that same plat, lots 8 and 9 were recombined such that lot 9 had frontage on both Jimway and Kingshurst. So this line here for lot 9, between 9 and 10, was shifted over slightly to here. And then the lot here that was dividing lot 9, what was lot 9, from lot 8, what was lot 8, which is the green dash, that line was moved and relocated to here to make what would have been a new lot 8 here. And lot 9 would have had the frontage here and included all that. And then you had lot 10. So that was in January of 2024 after the November 2023 purchase. Then in February of 2004, lot 8 was sold, and the deed for that referenced the original, had an incorrect reference to the original plat. So instead of referencing this boundary for lot 8, that sales deed referenced this boundary for lot 8, the original lot 8. So then a plat was recorded in April of 2024, book 73, page 709. And that was recording the shifting of the line between lots 9 and 10, and created some sublots out of lot 10. So basically they took lot 10 and put some sublots on it because they were going to develop some duplexes. And those have been since constructed. And if you notice on this plat that was in April of 2024, it still shows lot 8 being this area here. But remember, from the sales deed, the actual boundary reference from the sales deed is the green dash line, original lot 8. Then another plat was recorded in June of 2024, book 74, page 48, and that split lot 9 into 2 lots, what was thought to be lot 9. So that line, there was a new line added basically between here and what the rest of lot 9 was thought to be. So the idea was to create a lot here that was 70 feet wide. And then you'd have the rest of lot 9 with the frontage on Kingshurst and Jimway. And it would basically be this weird kind of H shape. That would have been lot 9B. However, remember, sales deed from January or February of 2024 still had this original boundary reference for lot 8. So basically this line wasn't carried through with the sales deed, but all the recorded plats still showed it. So now today, proposed survey, because this was sold as lot 8, and this has now later been sold as lot 9. So now Northway, they don't own this and they don't own this. They found out that they're left with this, and they found that out when they went to get a permit for building a house on what they thought was 9B, lot 9B. And they actually poured a pad for a house right about here.
That's why. I see, okay.
And so when they did that, they found out, oh, something happened, and then went back and found that it was the sales deed that incorrectly referenced lot 8 that was the result of the where we're at. So again, going back here, that I don't know if it's been torn up, but that concrete pad was somewhere in this area here.
And so those
In the
neighbors
yard of the owners of lot 8.
have now put a fence up around.
Right, so they've installed a fence around their property line to designate where that's at. And so that's why you can see, like, here's basically the lot that's remaining that Northway owns. And then there's a house built here on the adjacent property, which is lot 9A. So they can't go back and get additional property from them because they've already built and they've got a fence up, you know. So that's kind of where we're at and how we got there. And I can go through the variance findings before you guys turn it over to the applicants.
Okay, go ahead.
The unnecessary hardship does not result from the strict application of the regulations. Subject lot 9B was created when an error occurred in the sales deed for lot 8, and the resulting subject lot 9B does not meet the zoning standards for lot size and lot width, and is not a non-conforming lot. So it's not legally non-conforming. Essentially, it didn't exist prior to the ordinance standards. Incorrect recording of the sales deed for lot 8, which created lot 9B, put it out of compliance with the zoning standards. And an unnecessary hardship would not result from the strict application of the regulations because the applicant could pursue other remedies such as rezoning or court action to correct the deed error. The hardship does result from conditions that are peculiar to the property. The lot can't be developed as it is because it does not meet the N1A standards for the zoning district. And the lot is 7,076 square feet. That may be, I'm not sure why there's a discrepancy because it wasn't, let me say somewhere else, it was not 6. David Murray may need to clarify that. We have in here 6,996, 969 there, and then over here we have 7,076. So may need to get Mr. Murray to clarify the lot size.
Okay.
But it's 35 feet wide and it doesn't meet the minimum requirements of 10,000 square feet size and 70 feet in lot width. Hardship does not result from actions taken by the applicant or the property owner. Instead, it was a mistake that was made by the closing attorney when lot 8 was sold. The applicant and the agent state that the variance application and in their timeline exhibit that the applicant was unaware of this mistake until they began construction of a new home on what they believe to be the correct lot 9B. The requested variants are not consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. The requested variances are not consistent with the spirit and intent of the ordinance, as it would allow the N1A zoned lot that is substantially smaller in size and width than the ordinance requirements, and other lots in the neighborhood meet the N1A standards. And the purpose of the regulations is for lots in the same zoning to have similar sizes. And the intent is that the new subdivided lots meet the standards of the applicable zoning district and a zoning change is necessary to allow the creation of smaller lots. And the last exhibit is 14, showing the photo of the sign on the property. And that concludes our presentation.
Any questions?
So there are lots on that street that are 35 feet wide, right? Or is sublot?
Sublots, but not actual lots. Sublots don't have to meet the minimum lot requirements.
Gotcha, okay.
So that lot 10 has 4 sublots on it.
Correct. Two actual lots and then 4 sublots. I think it's 10A and 10B are the lots themselves.
Interesting. And so
What's on lot 9A now?
9A has I believe it's a single family house. Lot, and as I said, lots 10, 10A and 10B have duplexes on them. Nothing is on lot B currently, and then lot 8 has an existing single family house that was there prior to. And that was shown on one of these images had the house on it. Yeah, this one.
And can you summarize what the difference between a lot and a sublot is?
So a sublot is used for like, so if you do like a townhome or it's kind of like a condo ownership. So the land itself would be owned potentially by someone else, or it could also allow the sale of the home or sell the land with the unit. And then there's some common ownership of the overarching lot. I don't know if I'm explaining that very well, but essentially it allows for different ownerships and attached housing to occur in a residential scenario where you don't have to have the full lot go with the full dwelling structure.
So there's not gonna be a setback in between the two sublots. There'll be
Yeah, you would not have a sublot between, you would not have a setback between 2 sublots unless you were doing. Yeah, you wouldn't actually.
That'd be a townhome?
We would call that a duplex if it's 2, a triplex if it's 3 attached units, and a quad if it's 4. The zoning ordinance actually doesn't use the term townhome. Once you get above 4 beyond a quadruplex, it's considered to be a multifamily attached. But for common layman's terms would be a townhome, once you get above that.
Because they own the dirt.
Right.
but they are attached to each other.
Two units attached to each other, yeah. Any other questions?
All right, Mr. Murray, if you will step up, please.
We have this presentation.
Okay, all right, gentlemen, if you'll place your hand on the Bible, please. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? If you would each state your name and spell it for the court reporter, please.
David Murray. Murray.
H. Jared Levy. H is my first name. It's letter H, Jared Levi.
Okay, Mr. Murray, thank you.
Again, David Murray, here representing the applicant Northway Homes on this variance. We have a presentation here. Mr. Kinley's presentation was actually pretty thorough, based upon what we had provided. We're here just simply to do one thing, allow this lot to be buildable for a single family house. We're not seeking side setback reductions, front setback reductions, no setback reductions. The house that would be built would be as close as it could be without a variance. This is just for a lot that was the result of an attorney mistake and subsequent surveyor mistakes. And you'll see multiple levels of city review never caught this either. And then we ended up with this lot that's left over that is now effectively a dead zone if the variance is not granted. So there's two variances to clarify the difference in the number here. The application said 7,076 square feet because that's what GIS Polaris shows. However, when we obtained the updated survey for this site, the lot was 6,969 square feet. So there's a slight discrepancy between the Polaris and the survey that was submitted. And then also to reduce the minimum lot width from 70 to 35, which was the resulting lot width after the mistake. Slide 3 is the survey. Actually, sorry, I was wrong. The survey shows 7,076. GIS shows 6,969. So we're seeking 7,076 square feet minimum lot size. GIS shows it incorrectly. But this is our survey for this property showing the portion of 9B that's remaining. It's a slim parcel. As you saw in the pictures, you'll see more pictures here. There is development all around this parcel. This is what's left. As I said, when we started, the variance is necessary to allow this lot to be buildable because it, as in its current size and shape, it does not comply with zoning. And so a house would not be able to be built on this property. This issue came up nearly a year after the original plat was recorded and the original deed was recorded for this for the lot 8 that was sold out from this. And as you'll see, a lot of things happened in that year that led up to what has occurred. Slide 5 is the current picture of the property. Showing the fence on the adjacent lot 8, the old lot 8 lot line, and then the new home built by Northway would be on the left side of the screen here. Two more pictures on slide 6. Again, another view of the lot is on the left side, and then a better view of the distance between the existing house, the side yard of that house, and the lot that is at issue here today. Two more slides two more pictures on slide 7. Just a picture of the hearing on the right side, and then another view of on the left side is a view of the back of lot 8. You can see here there's some gravel that was for the driveway or the construction pad that had actually been put in by Northway for the construction. Another street view is slide 8. And then let's work through this timeline. So Mr. Kinley already went through the majority of this, but basically Northway acquired the original lots 8, 9, and 10. And that there was a single deed that they acquired all these together. And the intention was, as allowed under the UDO and the ordinance, to adjust some of the lot lines so that duplexes, single family homes could be built on these properties. And so on slide 9 is showing the original plat. And you can see this is shown on here, the original lot 8, and lot 8 had a house on it. In January 19th of 2024, Northway hires the surveyor. The surveyor prepares a recombination plat. It's submitted for review through Acela. It's reviewed by the city. This slide 10 shows the planning department approval. They reviewed it, went through the proper process, and the purpose of that plat was to move lot lines on 8, 9, and 10. And this plat superseded that old original plat. And so even the purpose statement, the purpose of this plat is to revise the common lot lines of 8, 9, and 10. And this is that plat. And so this plat moved the old lot line. This is slide 11. Move the lot line of lot 8 And basically what it did was it was preserving the existing house that was lot 8 and carving that out into a zoning compliant lot so that lot 8 could be sold. And then there would be more space for future subdivision of lot 10 for 2 duplexes and subdivision of lot 9 for 2 single-family detached homes. So Northway has an attorney that handles all of their closings, and they prepared a deed. And when the attorney prepared the attorney prepared the deed referencing the old lot 8, which was the description that was in the original deed to Northway, but did not reference the plat that had been recorded prior to. So the plat's been recorded. And when you do a real estate transaction, the plat gets recorded and then the deed references that prior plat so that everything is consistent with GIS. Except for the fact that because the attorney did it the wrong way and put the wrong description into the old block 8, the new plat didn't get picked up in the chain. So the new owner was deeded the old lot 8, not the new lot 8, as shown on the recorded plat. So this is where the issue started. February 1st, 2024 is where the mistake occurred on behalf of the lawyer. So Northway has sold lot 8, believing it's the new lot 8. They go back to their surveyor and say, okay, we need to do a recombination plat to sublot lot 10 so we can do our 2 duplexes. The surveyor doesn't pick up and realize that the lot 8 had not been deeded out correctly. It's submitted for review by the city again, and no one picks up that lot 8 is not matching up with the prior plat. And in addition, the surveyor even notes on the survey the new owner's names and shows the old lot 8, the new lot 8 outline, not the old lot 8. So everyone, city, surveyor, everyone included, at this point in time believes that slide 14 is what exists on the ground out there, that it's a large lot 9 and then 2 35-foot wide sublots for duplexes on lot 10 and lot 10. And then this carve out area is left. So move forward, slide 15 to June of 2024. The surveyor prepares another plat, submits it for review by the city. It's reviewed, approved by the city, stamp, as you can see here. Sorry, it's how do I go backwards? Yeah. So again, surveyor didn't see that lot 8 had not been correctly deeded out. So the new recombination plat still shows what they believe to be the new lot 8. And in the review process with the city, no one sees that there's an issue. This is that new plat. So the new plat is lot 16, again, shows what they believe to be the new lot 8 with the new owner's name on it. These lots on the left side have now been sublotted into the 35-foot wide lots for the 2 duplexes. And what we have now is a zoning compliant lot 9A and a belief of a zoning compliant lot 9B. This is what everyone believes to be existing at that time.
Mr. Murray,
Yes.
can you go backwards for 1 second? Just,
Yes.
I want to make sure I'm crystal clear.
Yep.
The correct lot number 8, which is owned by Zhang and Vang,
Yep.
they have a fence. Is it they who has a fence on the left side of 9B?
Basically, their fence is right here.
Okay. Is there something built on 9B right now?
No, today,
Today?
there's a slab that Northway poured and their connections for water and sewer.
In that pad we see right there.
It'd be basically where 9B is, and I have a future picture that I'll show you that.
Gotcha.
But as of this date of recording this, there is nothing there. There's no fence, there's no pad.
Understood.
But yeah, so they believe that there's a zoning compliant 9B and zoning compliant 9A when this is recorded, but nothing's built in those areas.
So the owners of 8 put a fence around what you're showing as 9B, but they have enclosed northwest slab.
That's correct.
Okay. All right, thank you.
Mr. Murray, is there any reference to the driveway easement in the deed for Mr. Yang?
I don't know. Do you recall, is there a driveway? I think it was in the plat. So if it's shown on the plat and the plat is incorporated into the deed, then that brings it forward. I think the problem is that the attorney didn't reference the right plat, so I don't know that there is a driveway easement.
In no condition.
Typically, it's not set out as a separate driveway easement. It'll say, there's that catch-all that'll say easement shown on plat or incorporated by reference by plat. And so that wasn't done. Okay, so here we are now, September of 2024. Northway pulls building permits for 9B. Under belief, 9B is as shown on the plat. And then through 2024, the construction's complete on those duplexes on the sublots. So here's an aerial of what it would have looked like in 2024. You can see the existing house that would have been lot 8. 9B is wooded. 9A has been cleared, and then you have the 2 duplexes on the sublots that would be on the left side of those surveys that we have shown. So here is the actual LDIRL approval that Northway submitted when getting the building permit for lot 9B. So this actually went to the city for review in August of 2024 prior to any building permits being pulled. So at this time, still nobody realizes that the lot line is not matching up, that there was the attorney error in the deed. The surveyor continues on not checking to realize that there had been an improper deed. And this gets submitted to the city. This is the LDRL approval showing the outline of 9B. And then there's where the house is going to be built. And it's just going to be one house. This wasn't going to be another subdivision of lot 9B. It wasn't going to be a duplex. This was just going to be a single house on this lot. And so
originally you did want to put 2 houses on there. You said that earlier.
no, there's on lot 9A, there's a house.
Oh, okay.
Yeah, this is just not lot 9B.
Okay.
Yeah, so so this is where the proposed house is going to be. This is slide 19. I think there's a zoomed in version. There you go. So slide 20 shows this is where the house is going to be. So this is the LDRL approval. The next slide is the building permit. But what this shows here is that they went ahead and put in you can see the service utilities. Those were already installed, and then they went ahead and built the slab. And here is the building permit issued. It says Kinghurst Drive, but remember this lot connects on 2 streets. So even though the variance is referencing Jimway, there is frontage on Jimway, but remember, since the lot 8 was deeded as the whole lot 8, what we have today technically doesn't have access on Kinghurst, because it would have if it was done as the plat shows, but for a single family detached house, just single house that was going to be built on this property. So got the building permit. So 2025 construction starts on lot 9A, which is the one next to it. That's the single family house. That house in June of 2025 is sold. That deed references the correct plat. In July 2025, construction starts on what's believed to be 9B, which is the Kinghurst address and the Jimway address. The slab is poured, taps installed, trusses are delivered to the site. And then the remainder of 2025 or late 2025, GIS finally catches up. because I don't know if y'all have ever checked before, but if you file a plat with GIS, it doesn't immediately show up in the system. GIS shows up, the county and everybody's reviewing the building permits and seeing what construction's going. And they reach out and they say, how do I get this thing to go away? Can I move it? So it's covering up.
Crystal has.
Seems to randomly disappear.
There we go. So Northway, so county advises, hey, there's an issue. The lot 8 was deeded and it's inconsistent with the subsequent plats that have been recorded. So Northway stops construction, reaches out to the adjacent neighbor and the attorney. The attorney has not been willing to work with us on this. He's pulled back. And there has not been any type of resolution. This is how it looked on August of 2025. So there's the slab that was poured. This is on the back of what would be lot 8 or what was believed to be 9B. So the slab was poured on the site. A construction driveway was put in, and then the taps for water and sewer were installed on the site. 2026. Fence was constructed around the perimeter of lot 8 as referenced in that original lot 8. The slab and construction driveway are still visible on site. I mean, you can't see it now because there's a fence, but you can see it in the aerial. And then what we have left as a result of this is just that narrow lot 9B, which is the focus of the variance here. And then here's an aerial from January 2026 showing the fence on lot 8 around the slab. And then this was the trusses that had been delivered to the site for that house were shown in January 2026 on the remaining lot.
So where's Mr. Rory in all this? See, his contract is gone. Because he had 9B, correct?
Yeah, 9B, yeah.
And 9B officially exists.
Officially exists. The reference was correct. Well, by that time, nobody knew, but the reference was correct. And so actually every reference was correct except for the first reference.
Deed.
Yeah, the deed. The first deed was a mistake.
Does Yang have title insurance?
I don't know the answer to that, but the problem is for that first deed, title insurance doesn't help going backwards. So it doesn't help a Northway situation. It would protect the subsequent purchaser, but then title insurance is just going to turn around and subrogate against the lawyer. It's basically how it works. I've only had one title insurance claim that I've ever filed ever, because I know that it ends up going back against the lawyer, and that's always a tough thing. So this is the lot. It's a deep lot. It goes back. One slight benefit here is at least that house is not on the 5-foot side yard. So visually there is a little bit of a separation there. And then this is where the construction entrance was into where they thought the house was going to be built. This would have been March 2026. And then there were some communications with the neighbor. They were trying, Northway was trying to see if they could resolve this. They were saying, look, we'll build the privacy fence. We'll give you, effectively this area to try to resolve this. We're, trying to separate this out. That didn't get anywhere. They made some offers. Then Northway was just trying to say, look, could you give us an easement to get to the water and sewer connections? So if we can put a house here, we can get to those without having to build new ones. The parties just have not been able to get anywhere. So here we are on our variance standards. Unnecessary hardship. Again, if the variance isn't granted, the lot's not buildable. So the hardship is it can't be built if there's no variance. So it was based upon, why is this necessary? It was based upon an attorney and surveyor mistakes. Northway went through the whole process believing that the attorney and surveyors had done anything correctly. The city did multiple reviews on this, building permits were granted. And it was not caught until after everything had been completed. Hardship runs with the land. It's directly related to the unique shape, size of the lot. It's 35 foot wide. Again, I had the wrong lot size there. It was the 7,076 square feet. But the lot stuck in its existing size and shape. There's, not really any benefit to an adjacent owner to have this property. It doesn't do anything for anybody because everything's already been built out on this, out in this site. So it is a dead strip of property without the variance. No self-created hardship. Again, the hardship here was created by the mistake made by the real estate attorney, and then subsequent mistake was further reinforced by the surveyor plat errors. The applicant, as you can obviously see by what occurred, the applicant didn't know that this was going on. Northway didn't know. They were unaware of this. They proceeded in good faith, believing that that everything had been done correctly. They obtained the building permits. They had the city reviews, the LDRL review. And I just note in here the Turek v. Town of Surf City case, which the Court of Appeals really likes to reference. They referenced it in the Sanders Partnership case recently that went to the Court of Appeals. But North Carolina courts have held hardships resulting from good faith reliance on surveys and permits are eligible for a variance. And secures public safety and substantial justice. The intent of the ordinance here is to allow a single family house to be built. This is neighborhood 1 zoning. This variance would allow a house to be built on this property. Otherwise, the lot is vacant. It's a dead space. There's no safety issues. We're not asking for reduced setbacks. We're not asking the house to be built any closer than it could be otherwise. Denial of the variance denies substantial justice to the owner that operated in good faith. We had a pre-submittal meeting. There was a question about rezoning. We had a pre-submittal meeting with rezoning staff. They were not supportive of a rezoning at all because the rezoning that would have to be obtained was an N1F, and there's no anything like that in this area. And so rezoning staff has been comfortable with maybe like a 1 jump from like an N1A to like an N1C if there's a 100-foot lot to get 250-foot. But we had the pre-submittal meeting. They were not supportive of this. That's actually what we did first. We did first to seek that. And then this is our last resort is the variance. And so again, there's a hardship because the lot cannot be built on. It's based upon the size and shape of the lot. It was created by an attorney and surveyor error, and substantial justice is to grant the variance to allow a house to be built. Any questions? Oh, sorry, H, do you adopt my presentation and testimony as if it was your own?
Yes, I do.
Maybe not the best solution, but have you approached the neighbors on the new build on the opposite, on the other side, asking if they would like to purchase that little sliver of property to add to their yard? I mean, I'm just asking you, that may not be a viable thing for you to do, but
It doesn't really do anything for them because they already have a pretty substantial side yard there.
okay.
And
That has occurred in the past. All right.
even if we were able to get some land from them, we'd still be here asking for a variance, but
No, I'm not asking them to give up any of their
Yeah.
property. I'm just wondering if you had approached them to offer to see if they wanted to buy that property. That would, but that's neither here nor there. All right. What happens with the slab and the connections that he's built his fence around? Do you have any? Is there any way that you can? Yeah. Is there any? I mean, you say mitigation. He's not.
It would have to end up in some kind of litigation, I assume.
Okay.
Is the back of 8 where the slab is
Hit that
now,
button. I think
is that need code to have anything built on it? So if we pass this variance and he builds a small house on 9A or B or whichever it is, can Mr. Yang come back and build a house there?
I don't know about the, I don't know. I guess possibly. It's not, it doesn't affect this, like there's space there.
I can answer that question. So
You can't have two principal
you can't,
structures.
you can't have two principal structures on the same lot that could be built, potentially have an accessory structure on it, but they would have to meet the accessory structure regulations for size and setbacks and all that, which, I mean, it probably meets the setback regulations. I don't know if it would meet the size regulations. So it may not be able to take up the entire slab, but you could have a accessory structure that use part of the slab and maybe have a patio or something out front or something. There's options of being able to use it for something in the future.
Can the new lot A be subdivided into two lots to allow two homes?
Lot 8, I don't know if it could be subdivided in its current form or not and meet the N1A zoning standards. We haven't really studied that to see if that would be possible.
So does the current owner of 9B, were they the current, were they the owner of lot 9, the platted lot 9, and they sold off 9A? Or is the current owner of 9B, did they buy 9B
9B
thinking,
purchased nine.
they purchased 9B thinking it was that H-shaped property?
No.
No, they knew it was 9B.
Okay.
So 9B, sorry, wish there was a quicker way to go backwards. So, sorry, it's 9A.
Right,
9A purchased, that's the single family house that's out there.
right.
They knew that they were purchasing 9A.
Sure.
That's what they purchased. 9B, it never got to the sale purchase point. Northway was building, poured the slab right here on 9B. They believed that they were on 9B when they did that.
So I guess my question is, did Northway buy a lot 9 and then subdivide it and sell off 9A? Or did Northway purchase 9B thinking that was 9B?
No, Northway owned lot 9B and lot 9A.
Okay, so they owned lot 9, subdivided it, and they were left over with what they thought was 9B. Okay,
Yeah.
Sold lot 8 to Mr.
right.
And this was all based upon the belief that lot 8 looked like that.
What is your understanding of the purpose of the pork chopping and having, I guess that's intent to have frontage on that other road so you could have side yard on the Gymway, or?
There was a focus on having utilities go through this area, was really kind of what the focus was originally, was to have the utilities run. And so there wasn't ever really, that the intention was always to have a house in this area, not over here.
It seems like a rather deliberate move to take all that area over along Kinghurst into a pork chop to.
I'm not certain, do you know?
Frontage and utilities.
Oh, it was for frontage and utility connections, yeah. Like this, once it was done, wasn't really necessary. If you saw, one of the proposals was for that to go to the lot 8.
I would like to make a clarification, or rebuttal, I guess, to Mr. Murray's statements. He said the city didn't catch it. I just wanted to clarify that we don't review sales deeds. So all we have to go by is the plats that are submitted for us. So every plat that it came before the city was compliant with the city standards. And so the city didn't have any knowledge that there had been some error that was made in a sales deed when in lot 8 was sold to Mr.
Yeah, and I don't think the city did, because we didn't either.
And GIS now picks that up? Or I was confused. by-
County handles that, so I don't really know what their
County
schedule
handles
and
it,
processing
unfortunately,
is.
sometimes it just doesn't update very quickly, so.
So I've never seen the deed references come up in GIS before.
No, well, so it's interesting you say that. So I just had a lawsuit that got settled in Dilworth and we closed the alleyway. The settlement was to close the alleyway. And we filed a withdrawal of dedication of the alleyway to clear that, but we also had to get a court judgment. We recorded a plat, but we also recorded a deed. When we recorded the plat didn't show up on GIS until we had a deed. So here you would have thought that when the plat got recorded and the deed got recorded, it would have shown up. But apparently it took a while to show up. So nobody ever noticed it. It wasn't like an immediate thing. And like in my other one, it took a while for that alleyway in Dilworth to show that the two property lines had closed in and closed that alleyway. It's just not an immediate, they don't immediately plat it as soon as it comes in.
It's not a reference to a deed, it's the actual lines in GIS. Something, there's something in
That
the
would be
computer
the
that
only
drops
thing.
the lines down
That would have
and
been the only thing, unless you went back and actually searched the title for lot 8, which they didn't do, the
Right.
attorney didn't do, then you wouldn't have known unless you would have gone to Polaris and it would have been updated.
did those lines ever drop down onto GIS? That 8?
This line never dropped down on GIS.
Okay, and once the lines dropped down, it went and
But
referenced the deed and,
If
oh,
if you're
wow.
looking at GIS and lot 8 had always looked like that, then you could look at it and go, well, GIS just hasn't updated because lot 8 originally looked like that. So it just hasn't updated to show the new lot 8. Well, then it just never updated. Well, it didn't ever update because the deed had the wrong reference. So it never changed when it got into the system. Even though there was a plat, the plat and the deed were inconsistent, so they went with the deed, so it never updated. So if you were looking at GIS thinking it was going to update, it just never updated because the mistake was never caught in the deed.
Is there anything that has to occur now because there's an inconsistency?
I don't think that there's anything that they can do unless you have a reformation of the deed, I guess is the only. I don't do a lot of that. So
So a reformation of the deed to match the original plat?
and then you're into, you know,
And so I guess they had to
but
have
the
been,
intention is just to have this lot, built.
yeah. I mean, there was a,
Sorry, the leftover lot, yes. Just
so what does the deed
Good
look
job.
like for the Vang property? Is it,
That's the deed that I referenced back at the beginning. That had the calls for the old plat.
so their deed, but did they have to re-record a new deed when they sold off portions of their property or?
No, because they were so this was carved out. So their deed looks like any other deed.
It's still, okay.
Their deed says lot 8 on it. But it's not lot 8, map book 73-314. It's lot 8, map book like 2. It's like
Right.
it's the original map. And then all the other subsequent transfers, all of those for the duplexes with the 35-foot sublots, deeds are correct. Deeds reference the plats, correct plats. Lot 9A, when it was sold, correct, references the new plat. So these show up on GIS correctly if you went to there now. What GIS shows is because this plat shows lot 8 with the old map book and page reference, it creates and it never changed the lot line.
So the
Wouldn't,
dotted
because the
line
deed
is
was wrong.
the lot line that
Yeah, the
that
deed
property
was wrong.
owns now.
So GIS has effectively shown that the only thing left after all the construction and sale of the homes is this 35-foot stretch here in the middle, and that's created the lot that we're seeking the variance on to be built on, because that's what has been left. as a result of that. This was not, I mean, this was literally the first thing. Well, the plat was done correctly. The first deed out, the attorney got it wrong because they didn't reference the correct plat. They just went, I assume, as happens with closing attorneys, they just go to the old deed, they pull the reference out of the deed, they copy and paste it over into the new deed. And that's what happened instead of referencing the new plat, because on the new plat and the old plat, it's referenced as lot 8, but it's a different description of lot 8.
So no, both Northwoods and Vang's deeds reference that old plat.
The original plat.
Right.
I mean, sorry,
The
the
original.
original deed.
The
When
original.
Northway acquired lot 8, 9, and 10, it referenced the old plat because that's what they acquired. When Vang was when he acquired lot 8, the lot 8 that was acquired was the old plat reference, not the new plat reference.
Okay.
So you had all these plats that were kept on being subsequently recorded. GIS does an update, everybody sees it. And that's how we're left with this situation. And unless the attorney would have gone back and seen it, it never got picked up. So everybody continued to proceed in good faith that this had been done correctly.
And so your outreach to the Vang family has not been successful in resolving this issue.
H can confirm that.
Correct. It has not been successful.
So when this lot A was sold to the Vang family, how was it advertised? Was the full yard advertised in the pictures and
No.
references?
No, it was always supposed to be just that section there.
And did they fully understand that?
Did they?
Did the buyer, the Vang family?
Yes. We never advertised the full lot.
And was there a sales contract that had a picture of this plat?
I can't speak on that directly. But we never marketed the entire portion.
Hmm.
That was never the intention.
Yeah.
And the other thing I just want to be clear on is this lot 9B as shown there was fully approved by the city, received permits. We passed inspections to do our plumbing underslab and then pour the concrete. So this was fully approved as is, despite the funny shape. Right, that was completely entitled compliant. And we were only gonna build one home right here. But because this land here was mistakenly transferred, we are instead asking that the property line, which now comes down here, we built one lot here.
Yeah.
There was never an intention to build 2 homes. We were gonna put one home here. And now, because this all went, we're just asking to put one home here.
And it's in one A zone, so you wouldn't have been able to split this up anyway.
Okay, anything else, Mr. Murray? Any other questions for Mr. Murray?
Is there opposition to this?
Yes, there is. All right, thank you, Mr. Murray. Before we hear opposition.
I'm sorry,
Oh, you have
I've,
one other thing? Okay, go ahead.
I have some proposed findings I'll pass out.
We're gonna take a 10-minute break before we hear from the opposition. Thank you. For the restroom, which I'll return. variance. If you would step forward, please, and be sworn in.
Ms. Dryden,
Yes.
I did find an answer to the question that Ms. Sun had asked about if lot 8 could be subdivided.
Mhm.
So lot 8, as it's originally referenced in per the sales deed and in its original form, could be subdivided, but they would need to address the setbacks with the existing house, or the existing house would have to be demolished in order to have 2 lots created out of it.
Okay,
But it is large enough that it could meet the N1A standards and have 2 lots on it.
if they tore down the original house.
Right.
Okay. All right. Thank you very much. Appreciate your visit here today. All right. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? All right. Would you state your name and spell it for the court reporter, please?
My name is Kervang, K-E-R, first name, last name V-A-N-G.
Okay.
I'm the owner of the property out there, 6201 Kinghurst Drive. I'm next to that. And let's see, the property here, when I bought it, the property, the realtor didn't even show me the map of what it looked like that, you know, it cut in front of I told him I never liked a map like that because it never showed me.
Mhm.
And when I bought it, the realtor told me this is, the line is a cross straight. It's a straight instead of cutting. That's my driveway. That's my driveway right there. I got no other driveway. That's the only driveway I think to pull in.
Where's your driveway?
This is driveway, exactly driveway right there. The one that they cut it to the, this is probably like the map, but I'm pretty sure that it's like they created a new map.
There's show us where your driveway is.
Okay. Yeah, here you go. The driveway is here, exactly here. And I put it's like a concrete here. And so I put another concrete here, make it a little bit wider when I move it in. And I didn't know that it belonged to Norway. And the property here, it's not cut like that. It was just straight. I'm not sure exactly where is my property because I didn't do the survey. The realtor just told me, so I'd say, oh, that's easy because nothing goes in front like that.
But
I
you,
didn't even know.
but
I
you
didn't
built
even
your
know
fence.
that map. It I knew the map was like that. I never bought the property. I'd be honest, who would? And it's gonna be hard to sell it. Or either refinance my property. The bank gonna reject. So that's why I think this is the hope, they created that map to build because instead of on Jinway here, they created that so they can build a house here, the slab on this property here to go out there. So it's the east, yeah, so they can have the eastman right here to come here so they can build a house here. So that's the only reason I oppose.
Well, so you must have figured out where your property line was because you put up a fence, correct?
Yes, correct, because I'm paying tax to the county since I bought the property. And I checked with the land record and they say that's my property. I'm not being paying tax for that. That's mine. So that's where I put trans on for my privacy.
Okay.
So you must have been surprised one morning when a concrete truck showed up and started pouring the slab. You thought that was their land, correct?
Correct.
And then at what point did you understand it was your land?
Well, the reason because the reason the pole that showed earlier, the electrical pole, show that it's the line because from that pole to my house. And the slab that they put on is like under the power line. So that's a danger for them to build. So the Duke asked me to give them permission to rewind the pole, repole, so they can build their house. That's why I found out that yeah, Duke that came and asked my permission. And they found out that, oh, it's a difference. So the Duke Power just forget it. They just threw the, pulled the back of the flag and they went home. They never put the pole in there because they knew that's my property. They could do nothing. So that's the only thing I knew that, yeah. Yep, that's oops, sorry. Yeah, that's a line go here, go straight to my house, right? That's the line. Yep. Mhm.
Okay, okay.
Oh,
Any other questions for Mr. Vang?
Um, I'm just opposed. I have no question. Thank you.
Okay.
So when you said you were opposed, it seemed like you were referencing the platting of the property back behind your house, but you're opposed to them building on that small piece of property back behind your house.
That's up to you. I mean, I'm not against on that one. It's not my property, but I'm here. That's impossible. That's 35 feet wide. That's impossible for me, just like, how they gonna build a house in 35 feet?
But aside from whether they can or cannot, I think what we really want to know is, are you in opposition to them building a building on that small piece of property? Is that what you're here in opposition to, or are you here in opposition to the determination of the property lines?
No, I'm not here for the property line. I knew that's a mine already, but I just go for the oppose for the new construction on their property.
Okay, you're opposed to that constructing a new house on that piece of property. Okay.
Thank you. Anyone else here in opposition?
I have a question for
Yes.
the applicant. At what point did Northway become aware of the issue? I think it was referenced in the timeline, but it didn't explain exactly how.
After 2025, after the slab was poured, that's when the county reached out.
Okay, so it's the county that contacted Northway, and that's
The
when
county,
the issue became,
yeah,
got us. Okay.
they reached out and then that's when, and H can confirm, but that's when the communications went with Mr. Vang that just testified, where Northway was offering and said, look, a mistake's been made. We want to make this right. We'll even buy it. And it didn't get anywhere. And so this is all that's left. But, this is the last resort. Otherwise, I'm surprised he's in opposition. If the variance gets approved, we're done. If it doesn't, then, this is our, this is the last administrative remedy that we have.
Okay, all right. Anything else before we go into deliberations?
I've got a couple questions
Oh, questions,
for
okay.
staff, I guess. So so staff's opposed to the variance
Oh,
or has not recommended a.
we're not recommending
Right.
approval of it. We do think that, there are options outside of the variance process. I know that Mr. Murray stated that they had spoken with the rezoning staff, and the rezoning staff that said that they would not support a rezoning. That doesn't mean that council wouldn't necessarily approve a rezoning, though. But it is a process to go through, and if the city council were to deny the rezoning, then they'd probably be back in front of you all asking for a variance. As far as the court proceeding option works, I'm not any sort of expert on those, but that would be another potential remedy, but that would probably cause a lot of other legal issues with all parties involved, from the folks that had, Mr. Vang and Northway and the attorney that did the closing, and potentially even real estate agents and all that. So, I know that there are some, I guess, challenges to those options, but those would be the options that, ideally you would take, as opposed to granting a variance, because again, we believe that this variance would, allow a lot that just isn't matching any sort of way. It's not even close to N1A standards of what you would get. And it wasn't created prior to the ordinance. So it's not a legal nonconformity in that regard, and that it's been existing for a long time, which you guys see those examples a lot. And so this is something that occurred recently and put them into this situation. So that's why we're not in support of the variance request.
When those lots were subdivided, how what you call them, where they put the duplexes,
Subplots.
the subplots, how wide are those subplots?
The sublot's are 35 feet wide.
But
The total lot width has got to be at least 70 feet
Right,
wide.
okay. So basically you would be putting a small house on basically a
A
sublot.
sublot, yeah.
Half a duplex.
You would have to meet they still have to meet all the setback requirements. So that's 5 feet on each side. And then, I think it's a 27-foot front setback and a 40
So
foot
it'd be like
rear
half a
setback,
duplex,
essentially.
sort of.
There's examples all over Charlotte of these 25-foot wide, basically shotgun houses, because there's old plats back in the day. They used to divide by 25 foot wide. There's even.
And I understand that.
Yeah, that's not true today. And.
Yeah.
No,
guys-
the old
Yeah,
reestablished.
But you've been here before and we have approved non-conforming lots that became non-conforming because of something substantial like Route 77 came through or 485 moved them.
Right.
That's not the case here. This is an issue that was created out of the ether. It was not because of something the city or the county did. That's where I'm kind of stuck on this one.
Right, but it was as a result of an attorney error and a surveyor error, and the case law on this is really kind of applying like a good faith standard, which is what really occurred here. This is, one of those really kind of unique circumstances where everybody did everything right, and then this was the result. And then you go back and look and you're like, how'd this happen? Well, the attorney made the mistake right off the bat. And then arguably the surveyor could have looked, but there wasn't anything, surveyors don't always go back and check the title. I mean, arguably should they? Yes, but do they always know? And so this is what we have resulting. The problem is, this is the administrative remedy. This is it. There is nothing else. And so a rezoning is not going to get approved. It's just not. And so even on my N1A to N1C rezonings, where I got 100-foot lot that I'm splitting it to 50 feet, the last one I had was a 7-4 vote. I mean, these are, the city council is pushing back on doing a lot of these rezonings. So this is the situation we have for this unique situation. If they had 100% caused this and said, look, we're going to be flippant about it and we're going to try to get something we shouldn't get. But that's not what happened here. That's not at all what happened. In fact, the neighbor is ending up with a situation better than he should have, but yet he's still in opposition to the house getting built. That seems inconsistent to me.
I'm curious to know if a remedy that you have you pursued a remedy of repurchasing lot 8?
Repurchasing lot 8, yes.
There's the two
H can
lots.
confirm that. H, you want to confirm? Stand up here.
That was not amicable, that was not amenable to Mr. Vang, okay.
A couple more questions for staff. So unnecessary, I'm noticing that you got 4 conclusions of the law. On the first one, unnecessary hardship would not result from the strict application of that regulation, but you are saying that the hardship does result from conditions which are peculiar to the property. And you are saying that the hardship does not result from the actions taken by the applicant. But then you are saying the requested variances are not consistent with the spirit and purpose. So 1 and 4 are disqualifiers, I guess, for the variance would be
Correct.
okay.
Something just with respect to the case that was cited, because Mr. Murray is correct that that case does say that the board can, a survey and error can make a site eligible for a variance. But I think it also, and I haven't looked at it in a long time, but you can look at the degree of the hardship involved. and my recollection in that particular case, and I did look it up, it was, the amount of the variance was like a 7.2 inch variance, and it was, would have required the demolition or substantial alteration of an existing or partially complete building. So, it's important to look at the facts and circumstances of the particular case. And so I just didn't want you to get the impression that, you can't look at the degree of the hardship or all the factors in that case, in this case, based on that case.
Thank you.
Thank you. That's good to know.
Yeah, and it's been cited a lot, though,
Okay.
just so y'all are aware of that.
Well, I mean, I understand, and it says it can be, it doesn't say it shall be.
So
but
totally
thank-
understand.
I mean, I
was just
understand that,
stating
Mr.
the
Murray. And,
circumstances.
all right, you had another question for staff? Okay, any other questions before we go into deliberations?
Just for, make
Clarification.
sure we have our numbers right. The 7,076 is the correct square footage, right?
Yes,
Okay,
for
that's
number
correct.
13, correct.
That would, in the staff's findings document, that would be a change to number 4. 13 is correct.
That's what the survey showed, isn't that right?
Right, so in number 4, it's instead of 6969, it should read 7076. Okay,
In the applicant's findings that Murray provided, it looks like number 5. The number 5 need to be revised.
Yeah, number 5. And then I put the wrong case number too by accident.
okay. All right. Any other comments or questions before we go into deliberations? All right, thank you, Mr. Murray.
Ms. Dryden, since this one was contested, can we just make it clear that the hearing is closed?
Yes, the hearing is now closed. So the board will deliberate. You're welcome to sit and listen, but we'll take no other comments. So let's make sure that everybody had all their questions asked of everybody, so I don't have to reopen the case. Okay. All right, who would like to start? Thoughts?
I can start. The subdivision of the property with the sort of H-shaped pattern and the frontage made me kind of curious and skeptical about, whether this was some kind of trick being played, if they were trying to figure out how to squeeze another piece of property out of this. And if this was maybe the ultimate goal, whether maybe particularly since the current property owner was the original property owner that kind of created all these crazy shapes, it made me a little skeptical that maybe they were not working in good faith. But I couldn't find any reason to believe that there are any games being played here. I do feel like the property owner had been working in good faith through this effort. And that they would have a hardship that would result from the strict application of the regulation. I personally, this may be just a side note, I don't personally fault anyone who gains from the misfiling of a document. I mean, I think that is fair game. There's lots of injustices that happen from one direction or the other. If it happens in your benefit, I don't see any, I don't carry any ill will toward that. I think that this has resulted in some loss of value to the current property owner of this parcel, and the allowing them to develop in some manner would give them justice of some sort. So I would lean toward granting this variance.
Okay. Mr. Williamson, what do you think?
I think it's unfortunate, and I think it's I don't think it should have gotten to this point. I think it should have been taken care of, with the purchase of that remnant of the lot or some other way, with the real estate brokers and the attorneys, to compensate them justly. I'm not sure I would vote for the variance.
If we
Okay.
could have some discussion on the criteria, whether or not, you think there's an unnecessary hardship.
And I have them right here.
I would agree with Mr. Williamson that this is not the right jurisdiction for a case like that, because the right course of action would be to pursue compensation from the attorney that made the mistake and the realtor that, whoever involved that caused the issue in the first place. And instead of coming to ask us to stretch the variance, standard again, and in such a degree, because N1A is not supposed to be just 35 feet
Correct.
frontage. It's like forcing us to make exception just because someone else, that they can still pursue legally for a compensation to remedy it.
Well, Mr. Shea, you want to comment first or you want me to?
I would say that I always lean towards owners have the right to develop their property and use their property. But this is so far in right field that, and it's not because, like I said earlier, this lot is non-conforming, not because the city or the county did something or the state did something. This is an error that was not because of a government institution. So I don't particularly feel any obligation. As much as I always lean towards people having the right to develop their property, this just seems to be too far to the right to be to fit into these conclusions of law that we normally follow.
My issue is the precedents that we set on this board. Basically, what they're asking us is to do a subplot on this piece of property. And I agree with Mr. Shea, the county and the city and the inspectors had really nothing to do with this error. It was way back when the property was first subdivided. And, I hated that the developer was not more forthcoming in figuring out what this lot would look like. Even how they were going to subdivide it was crazy. Or, well, I take that back. That's not a good word. Didn't seem appropriate. And I believe if we go back and listen again to Mr. Murray's presentation, at the very beginning, he said that the original thought for this property was to put 2 houses on it. Now, maybe they have come full circle with that now that they have, they were only going to put 1 house on there. So, but that was my understanding from his earlier presentation. And looking at, it says an unnecessary hardship would result from the strict application. Well, yes, it would be a hardship, but I don't know that it's necessarily an unnecessary hardship. Results from conditions that are peculiar to the property. Yes, that is a hardship. It's peculiar. But it says the hardship did not result from actions taken by the applicant or the property owner. They did not, but their attorneys and the previous people who they hired to look at this did. So in a way it was caused by the applicant because they weren't, what I've said all along sitting on this board, as a property owner, you are ultimately responsible for everything that happens on your property. If you give it over to a contractor and the contractor does it incorrectly, it's not our job to fix what the contractor messed up. You can come and ask, but again, this is not the city or county's responsibility that this occurred. I hate it for them. I have empathy for this developer. But I don't feel like we can bend these rules that much to have this property plotted basically as a subplot into a regular plot of land. So those are my thoughts on this. We can, if anybody else has anything else to say,
Mr. Rodden, I think there was a factual misunderstanding. I would recommend that we reopen to. let-
okay, if we can reopen this for Mr. Murray to clarify that.
I want to clarify this, not an argument, this making sure testimony is clear. On original lot 9, there was going to be 2 lots. There was only ever going to be, 2 houses. There was only ever going to be 1 house on lot 9A and 1 house on lot 9B. So there was not going to be multiple houses. It was just the original lot 9A, which was split. The lot that we have left over is the remainder of the lot 9B. And lot 9B, even though with the unique shape, was only ever going to have 1 house.
Okay.
So I just want to make sure I'm clear on that.
Well, thank you for that clarification, because that's not the impression I got when I was confused when you said 2 houses. You were considering the house.
I was talking about original lot
original
9A.
lot size. Okay, thank you, Mr. Murray. I appreciate that clarification.
And if we could reclose.
Okay, so now we will again close the hearing and, okay.
I make a motion to deny.
All right, so Mr. Shea
That's good.
has made a motion to deny. And Ms. Sun has seconded. All right, Mr. Williamson?
Williamson. Yes, deny.
All right, yes to deny. All right, Mr. Shea,
Jay, yes.
Ms. Sun,
Sun, yes.
Mr. Court?
Court, no.
Court, no. And Dryden, yes to deny. All right, so the variance has been denied. And looking at the finding of facts and conclusions of law, I think the only corrections were in number 4 and number 13, where we had to change the square footage to 7076.
I think it's just 4.
No, it was on number 13 also. Oh, no, the 13 was right.
13's.
Okay, so it's just number 4 that needed to be changed. Okay. All right, do I hear a motion to approve the finding of facts and conclusions of law with the one edit?
These are the ones that were presented by staff.
Yes, this is staff's presentation.
Wait, is it 4 or is it 5?
It's
4.
4. It's the minimum lot size for the required 100 is 7076. Make sure those are Murray's. You need to look at
Oh,
those.
okay.
That one.
Yeah.
It's number 4 on that one.
Okay. My bad.
Okay. Right. Okay, do I hear a motion to approve with the edit?
Approved.
Thank you, Mr.
Yes.
Williamson. Do I hear a second?
Second.
Thank you, Mr. Shea. Mr. Court?
Court, no.
No, okay. Ms. Sun?
Sun, yes.
Mr. Shea?
Shay, yes.
Thank you.
Williamson, yes.
Okay. And Dryden, yes. So by 4-1, the finding facts and conclusions of law are approved. And by 4-1 vote, the variance is denied. Okay. All right. Thank you. Now we need to look at the minutes for approval. So if you could scan those for just a little bit, please.
Make a motion to approve.
Thank you, Mr. Shea. Okay, where's the paper? Sorry. All right, Mr. Shea had the minutes. Do I hear a second?
Williamson, second.
Thank you, Mr. Williamson. All right, Mr. Court,
Court, yes.
Ms. Sun,
Sun, yes.
Mr. Shea,
Shay, yes.
Mr. Williamson,
Williamson, yes.
and Dryden, yes. So the minutes are approved. All right. I believe this concludes our meeting for today. Thank you for joining us.